Hello friends, Namaskar. Today I am going to discuss an important update concerning the expedient disposal of child custody case. There is a common queries from your sides that we are having a child custody case on board and it is pending since a considerable period of time. What to do? Whether we should leave our idea to contest the child custody case or whether we have to wait and watch. What to do? I know that being the father of a child, you are getting emotional because you are not getting an opportunity to meet with your child. You are totally helpless. What to do? The same is occurring because you are not having the proper legal information or knowledge on this subject. So, in the present class, I will discuss each and everything in the efficient manner. Please note down the important points. First of all, we will note down the judgment name which could help us in this journey. Judgment name is K.S. Sumi versus Suresh Kumar. Judgment is available at live law. It is pronounced by Honorable Delhi High Court and judgment is pronounced on 31st of July 2030. Application number is 23305/2023. In that case, specific guidelines are propounded in terms of limitations so that we could have the proper disposal of child custody case not in the routine way but in the expedient way. Please note down the guidelines which I am going to narrate you. And please maintain the notebook with pen or pencil so that whatever I am going to narrate you could be maintained by you in recorded format so that if you are having the issue, you could easily contest the same without having any legal help and without getting any worry or panic on the issue. I am here to make the legal provisions for your better understanding in a simplified way. So the first point is the filing of case. You know, when a case is filed before the competent court, it must be in a proper format. And apart from that, when a case is filed, the summons are issued to the opposite party. And usually date of 2 months, 3 months, 5 months is given. But this judgment is going to change your journey. It says that when a case is filed, summons is to be issued and next date of hearing is to be given, but within a period of 30 days. So it is going to make your journey more smoother on point of limitation. Apart from that, when the respondent appears, the respondent has to file the reply. That is called written statement. But it is to be filed within a period of 30 days. And the period counting will be initiated from the day of service of summons. Apart from that, the period could be extended, but not more than 120 days to be remembered. So the concerned respondent could not delay the proceeding. She has to file the reply at any cost within a period of 120 days maximum. Although the period is 30 days, but it can be extended. So we are saying that the maximum period for filing of reply is 120 days. And in the meanwhile, you may submit the application for the interim custody or visiting rights on the ground that the concerned respondent is causing delay. Without having the proper reason, she is taking time just to file the written statement so that she may prejudice my right. And you have to emphasize on the said protocol without getting any worry or panic. You are not saying that is your problem. And I am causing you to learn how to say. It is to be noted that in case any application is filed for the inspection of documents, it is to be filed within the period of 30 days, not more than 30 days. And if it is filed, it is to be disposed of within a period of 30 days, not more than 30 days. So on point of limitation, we are getting a smooth journey in a child custody case. The practical problem is that we are not saying and we are not making our objections. Simply we are saying, my lord, date is not to be given. She is making a delay. File application on each and every date with specific reasons, and apart from that, we are supposed to file such applications as per section 151 of CPC to get the proper remedy. If we are not filing, if we are not making the objections in the writing, we are going to prejudice with our own rights. Be remembered. Apart from that, there is a stage of admission or denial, which is most important stage to make the trial process more effective, for which only 4 week time is given, to be noted that. And for the admission and denial, we have to rely on Order 12, Rule 3A of CPC. The purpose of admission denial is that, for example, there are certain facts which are uncontroverted. The opposite party may admit the same. It will definitely help to cut down the lengthy trial process. So the process is very much beneficial. So if the court is avoiding that process or deliberately it is not averted, then you may put in the same that as per the protocol, admission or denial is must. If we are not adopting that process, we are going towards a complicated trial, and we never want a complicated trial, specifically in a child custody case, because in getting of judgment, it is submitted by Honorable Supreme Court that for the welfare and development of child, the prime considerations is to be seen or observed by the consent court. The litigations are too much common. The husband and wife are fighting for their own right, but in the legal battle, we cannot affect the rights of the concerned child because we are emphasizing on the welfare and development. In addition to this, 6 month time is given to both the parties to record and to submit their evidences. If they fail to do so, further opportunity cannot be given at any cost as observed in this judgment. In addition to this, the written statement to be filed after the same, and the case will be disposed of within 15 days after conclusion of the written arguments or oral arguments. So these guidelines are quite important for us for the expedient disposal of child custody case. Now, we are not supposed to wait for the infinite time for having the justice, because it is the general mythology prevailing. Even in our country right now, justice delayed is justice denied. So we have to emphasize on all such protocols and should have the effective remedy as per the protocol. And apart from that, if there is any intervening obligations like interim custody or temporary custody or visitation, it is to be filed and it is to be disposed of within a period of 90 days from date of filing. So when the protocols are available for your help, just you have to plead your submissions in the proper format, in the written format, so that you could submit your arguments in effective way to ensure justice not only for yourself but also for your children who are still waiting for you. They are still waiting for your love. They are still waiting for your emotions. So I think that I am totally able to cause all of you to understand what to do in such a scenario. See you in the next video. Till then, Jai Hind, Jai Bharat.